to your commercial courts and divisions. Again, there is a qualification relating to whether commercial court will have a jurisdiction or a regular court will have a jurisdiction. It's what three examples like case like this. Now, Vishal Pipes matter, Delhi High Court said, with respect to intellectual property law. I'm sorry, I'm going to rush a little bit because I think you all have time constraint. It says IPR dispute, trademark copyright violation disputes, should be first filed before the commercial court. Then the commercial court to establish what sort of valuation it is and determine approximately the value, whether it's 3 lakhs or above. If it's less than 3 lakhs, should be shunted to the regular civil court. Now the problem is, every case has to be filed only before the commercial court, irrespective of the value. The second problem is that when I want to file a suit for injunction suit for infringement, I will not know what sort of value I should claim. My IPR valuation may be several crores, but the infringer may be doing on some part amount, maybe 1 lakh, 2 lakh, or less than 3 lakhs. Are we going to burden the commercial court with such a problem of determining the valuation? We don't. Now, our Karnataka High Court came out with another judgment in Fine Footwear versus Skechers USA. It made it mandatory that whoever files a suit in Karnataka should have a specific clause, specific government that there is a specified value of this suit is so much. The registry should examine whether it's 3 lakhs or less than 3 lakhs. If it's 3 lakhs and above, it should go to commercial court, provided it's a commercial transaction. I had a very interesting case. The first case which I said, a suit for bare injunction by a trespasser, is there's a tenant, there's a lessee and a sub-lessee. The lease agreement prohibits any subtenancy or sublease. It's not been ratified by the landlord. Landlord wants to throw him out. He goes and files a case. Court grants an injunction not to be disposed of, with no declaration, not to be disposed of without the due process of law. That is challenged in the High Court by way of a writ. In the writ proceedings, the court says, listen, you have to specify the value. If you have not specified in a suit for bare injunction, then the court has to determine. This, in one hand, we have been complaining about backlog of cases. The court's being burdened with all this. Now, every time an application is going to be made or it's to be determined, the court said, let the defendant make an application in the court, and the court has to decide whether there is what's the value of it. So, this is causing a lot of problem. The law also says, Commercial Courts Act very clearly says, there is a limitation on commercial courts. Wherever there is an express or implied bar ousting the jurisdiction of the civil court, then civil courts, commercial court cannot entertain such disputes. I had mentioned earlier, definition of commercial disputes includes shareholder subscription agreement, investment agreement, which are purely to be construed as dispute before the National Company Law Tribunal. But at the same time, in Arun Oswal's case, the Supreme Court has held, in a suit for partition, even though the dispute may relate to commercial transaction, NCLT has no jurisdiction. So when jurisdiction of NCLT is ousted, then where do we stand? We have to come back to civil court. But this law says something different. NCLT cannot be a fact-finding court as regarding title. Another interesting case on companies background is that employee stock option plan a plan that has been approved by the Income Tax Department and the government. Stocks not paid. Why should they go to NCLT? The Delhi High Court says commercial courts has due jurisdiction. So with such a confusion as to what would constitute a commercial dispute, what would qualify as a commercial dispute is going to really determine, really going to create a lot of work for us. And we are not going to stand with that. But another qualification is the pre-qualification, assuming it's a commercial dispute, we have to first invoke PI, pre-institution mediation under section 12A. Chai exports case, which has now been overruled by the Supreme Court, Madras High Court held that it is voluntary. You can't compel someone to go for mediation. But unfortunately, it contradicted AFCON's ruling of Justice Ravindran of the Supreme Court. The concept of Justice Ravindran's ruling in AFCON's case is, yes, no doubt mediation is voluntary, but the concept is step in but opt out. You go for mediation and say that you are not willing to participate in the mediation room and walk out. You are not forcing, and the mediator cannot force you to sit. That was the principle behind it. Whereas the other courts, the Bombay High Court and Lakshmi Purfar, Calcutta, said Natives case in the Supreme Court has put down that, hit the name very clearly. Section 12A, pre-institution mediation is mandatory, except when there is an application to consider urgent reliefs. So if you file an application for attachment before judgment or injunctive relief or any other emergency, you are not covered under it. But at the same time, the Supreme Court says it's concerned that if you file a frivolous application for emergent relief, you are circumventing section 12A and says the lawmakers have to look into it. So it's left to the artist to perform. But also it says that if you, when you have a limitation constraint, in the fag end of your limitation period, you go and knock the door of the commercial courts without exploring section 12A, the plaint has to be rejected by the court akin to Order 7, Rule 11. Once it is rejected, and if you have lost the limitation, you can't refile it. So that's a risk. So when we talk about mediation, I'm a very passionate mediator. I'm a horrible, people know me, Arvind will tell me, when it comes to litigation, I fight. I just don't give up easily. But at the same time, when it comes to mediation, I'm a proponent of mediation, though I oppose introduction of section 89A into CPC, oppose mediation. But there are circumstances which change my mind. What changed my mind, I'm going to explain very briefly because I want to open the floor for discussion. A survey conducted in 2008 gave a shocking revelation to us. 9% of the disputants considered court and lawyers would give the relief. 9% of the disputants. Survey conducted in 5 states, including metropolitan. Only 9%. People who believe court and litigation will not provide solutions were 52%. People who believe arbitration or ADR as the best option is less than 1%. People who believe politicians and police or bureaucrats can resolve the dispute is 29%. But another 9% believe mafia is the best way. Underground, go to underground club. So I always wondered, my God, I am the august company of the mafia. And when 91% of the disputants are excluded from the courts, what makes us say that there is docket explosion? I don't believe in this docket explosion. If courts, with due respect to the Supreme Court today, all the courts, if they say there's a docket explosion, there's a backlog, it does not reflect very well on us. It shows there's a failure of administration, not the lawyers. It's not the courts as such. Imagine if one person from this 91% shifts to the court, we'll crumble. My appeal to my brother lawyers and friends is always, it's a new paradigm of profession shift for all the lawyers. There's a lot of money in mediation practice. If only 9% we are worried about, what about 91%? We have a larger pipe, is what I want to say. And that motivated me. And the fact is that I fight as a litigator, but more I fight every time when a matter goes for mediation. My client comes back and says, "Sir, I have one more matter, get it resolved through mediation." So mediation cannot be a threat. But at the same time, I want to talk about the Mediation Act 2023, which was passed recently in Parliament. What does it talk about Section 12A in mediation? And as it became mediation, as the Act made the mediation compulsory. It is not. As far as Section 12A of the Commercial Courts Act, Section 5, proviso to Section 5 of the Mediation Act 2023 makes it clear that pre-institution mediation in commercial courts is mandatory. It becomes an exception. So what about Section 89? Or in civil court, pre-institution mediation is not mandatory. So that means Section 89, read with Afghan's case of the Supreme Court, will still hold good for reference made by courts under Section 89. So as far as commercial courts are concerned, we need to find out a solution what really fits in the ambit or qualifies as commercial dispute, irrespective of that. Second is there a conflict when it comes to valuation with the Court Fee and Suit Valuation Act? Court Fee and Suit Valuation for an injunctive relief, bare injunctive suit, is valued at 1,000 rupees. If the court is going to say, come on, determine a specified value, and the specified value is silent as far as commercial court is concerned, it says it should override. There's no amendment to the Court Fee and Suit Valuation Act. Wait, what do we follow? Friends, no doubt the Commercial Courts Act is welcome because it's an expeditious disposal. We lawyers, many of our lawyer friends find it easy because it's a time-bound program to dispose, and they get the fees early, and the client gets a relief also. But at the same time, there should have been a little more concern as to avoid confusion in the nomenclature related to commercial dispute. What is a commercial dispute? So there should be more clarity. With that, I once again thank you all for giving me this opportunity. I welcome any questions from all of you. Any questions, sir?
Question about pre-institution. How did you resolve that dispute? Injection relief, asking the civil court whether it is reasonable or not. What is the consequence?
Okay, that is it. Well,
first case.
Well, I went back to the trial court. Okay, the counsel engaged me, sir, come and explain. All that I said is, the other two examples I gave. If this is a matrimonial dispute involving a commercial property, is the jurisdiction ousted? Should this matter, because a divorce proceedings, can it be handled in a commercial court merely because it relates to a commercial property. Please decide. You have seen the jurisdiction. The second example I gave is, I am traveling in a bus. I buy a bus ticket. The bus meets with an accident. I suffer an injury. It's a commercial transaction. Transportation is a commercial transaction. Buy a ticket. If I have to claim compensation under Motor Vehicles Act, I should go to jurisdiction of the commercial of the motor MACT tribunal. MACT. There is an exclusion. But the thing is,
yeah, there is a specific remedy.
The specific remedy. Now, what do I do? What should I follow? These are the issues which simple thing, in a sense, make someone to think that where they are going wrong. Not all cases will fit in the ambit of commercial courts. At the same time, not all commercial courts can be called as commercial dispute. That's the reason I use the word qualification. A rose is a rose is a rose. Not all commercial disputes are not commercial disputes. Any other question? 12A, that's sir wanted.
No, the extraordinary, sometimes for interim relief, people will approach just for filing. How to justify?
Sir, the thing is, and that's what Justice Matthew says in his judgment in Matthew's case. He says, the lawmakers should think about to prevent people using an application for interim relief, which is frivolous in nature. The court should determine whether there is an urgent relief, urgency involved or not. If the court is going to issue ordinary notice, not an emergent notice, there is no urgent relief as such.
No, I will claim it's an emergency.
You may claim, but court, it is left to the discretion of the court. But there is no provision in the Commercial Courts Act. Section 12A has been drafted in such a manner, there is no clarification as such. What is an emergent relief? The sad part is today, it's my personal view, that lawmakers, the law is litigation.
Is it not a duty of the court to make some guidelines? What is the emergency situation? Instead of leading it to the
unfortunately, they don't want to take the role of lawmakers. That's why Justice Matthew says it is left to them. But it is left to them, it says. So the court cannot do it. In fact, there are cases where when I conduct training program for judicial officers, they say, sir, can we invoke section 89 and therefore, I said, you don't have the power under section 89 when it comes to commercial courts. You have exhausted the remedy. Let there be a ruling. That is the reason I said it's a nice artistic modern art. This modern art needs to be interpreted by us or by the courts and give an explanation. Each one will look, okay, if it's a Picasso drawing, okay, we can say this is so and so, this shows a, you can say it's a face of a lady, no, it's a face of a duck. Okay, so our law are now giving a lot of scope for lawyers to interpret, more scope for litigation. So very effective in Bangalore. Very, very effective.
Very effective. One more thing is your experience, whether family disputes are resolving in this
No, it's not, cannot go at all. Family disputes cannot be dealt by the commercial court. This is what I argued before the court. If you look at the act itself, anything related to it all. The word relative causes a lot of confusion. Okay.
Thank you, sir.
So before I'd like to present 2 copies of that book to this great library.
President, thank you. President.
and there's a draft, there's a declaration recommended by the United Nations, which is not compulsory. You can encourage any lawyers, bar associations to voluntarily sign such a declaration. One of the things.
Is there another top one?
Sir, thank you very much.
It's very important on ethics.
Respected President, my dear members, Mr.B.C.Thiruvengadam, Senior Advocate, Karnataka High Court, Mrs. Thiruvengadam, and my dear friends, it is with immense pleasure I propose a vote of thanks to Mr. B.C.Thiruvengadam, Senior Advocate, who has come from Bangalore for this session on Commercial Courts Act 2015. Thank you very much, sir. On behalf of the Madras Bar Association, I request you to visit us once more. This is a very lucrative area of practice. So, we members, probably due to some time constraint today, Monday being a very busy day, first day of the week, some of the members who are practicing on this side are not present today. So, any future occasion, whenever you come to Chennai, please let us know. We will have one more session on the same topic, sir. More interactive session has to be there in this topic. As you deliver more lectures on this, more doubts will come from the learning. Thank you very much, sir. Thanks to all the members.